Thank you, Mr. Speaker, and I'm pleased that as we continue this debate on the Canada-Korea trade agreement, and particularly C-41, the bill to bring the treaty into effect, that as the leader of the Green Party of Canada, I'm able to put more fully on the record the position that I've stated so far through questions and comments, that we will not be supporting this treaty. I can explain the fundamental reason and then go into some of the details. Fundamentally, the Green Party of Canada will never support an agreement that includes an investor-state provision. We believe investor-state provisions are, by definition, anti-democratic. By definition, the notion that we should allow a corporation or investor from another country to have superior rights to Canadian companies in response to Canadian laws, whether passed at municipal, provincial, or federal level, is offensive. The first of these was Chapter 11 of NAFTA. I'll go into some more detail later as to why we oppose investor-state agreements and the particularities of the Canada-Korea agreement. But I also want to back up and say that in the Canada-Korea treaty, the Green Party believes we missed our opportunities to ensure that we had a more balanced deal. Let me say this about South Korea. What a tremendous economy they have built. In the wake of the collapse that was brought about by currency speculation, by the trading in currencies that created a meltdown for what was then described as the Asian tigers, Korea, through a lot of state-led economic policy, has rebuilt an economy and has built an economy that is championing renewable energy, as some of my colleagues from the NDP have mentioned, championing clean tech. There's a lot to be admired in what South Korea is doing. And so the comments that I'm making about this trade deal are not in any way to suggest that South Korea isn't a really impressive democracy doing a lot with technology. The difficulty we have is that the way this trade treaty is going to go forward, we agree with the concerns of the auto sector in Canada. Both the CEO of Ford as well as Unifor, representing the workers, that we will lock in our trade imbalances. We will not reduce them. And I know that some of my colleagues have mentioned Unifor. Let me mention, and let me read into the record, the views of the CEO of Ford Motor Company of Canada, Diane Craig, who said that in response to this treaty, quote, South Korea will remain one of the most closed automotive markets in the world, unquote, under the New Deal. She went on to say that the trade agreements that the U.S. and the European Union have executed failed to reverse their negative trade flow, but those treaties were more protective of their domestic car market than Canada's treaty with Korea. As she said, and this is again quoting from the CEO of Ford Motor Company in Canada, quote, no Canadian manufacturer can compete with a market controlled by non-tariff barriers and currency manipulation, unquote. And of course, we know that this agreement doesn't deal with those barriers to Canadian automotive access to the market. Now, it's quite true that we have a lopsided relationship in trade with Korea. In 2012, we were exporting $3.7 billion worth of exports to Korea. That's an impressive number, $3.7 billion. However, we were importing $6.4 billion in imports from Korea. And the story of what constituted those $3.7 billion worth of exports and $6.4 billion worth of imports is worth touching upon. Canada has largely been exporting raw resources to Korea. And under this deal, the commodities that are touted in the materials that accompanied the deal talk about what this will do to improve agricultural exports and raw commodity exports. Whereas we look at what we have been importing from Korea and its high-value manufactured exports, rather imports. So when you look at what Canada has been exporting to Canada, to Korea, let me just quote from Jim Stanford, who is the economist, Jim Stanford, rather, a very respected economist who works with Unifor. And he puts it this way, quote, we export mostly raw material to Korea and we import sophisticated high-technology products from Korea. Continuing the quote from Jim Stanford, economist, quote, Canada's top 4 exports to Korea last year were coal, copper, aluminum, and wood pulp. Our top 4 imports were motor vehicles, electronic circuits, auto parts, and smartphones. Now, there's nothing in this trade deal that's going to change the characteristics of what we're importing and what we're exporting. And the history that we've seen, and I referenced it in the quote from the CEO of Ford Motor Company of Canada, she certainly mentioned the fact that the experience with the U.S. and the EU having concluded a trade deal with Korea, that did not change the gap that existed in trade flows. In other words, having executed deals like this and ones that were more protective of their auto market, they still saw the trade deficit with Korea expand. So there's something wrong. This is a larger conversation I'd like to have someday in this House, Mr. Speaker. Green Party believes that Canada is losing out in productivity and in R&D by allowing our exports to be skewed over the last number of years from 60% value-added exports to currently 60% raw material exports. Being a compliant resource economy for other countries around the world is not in the best interest of our economy and certainly not in the interest of rebuilding our manufacturing sector. Now, I turn quickly to the issue of investor-state agreements. Again, by definition, they're perverse, but it's interesting how different they are becoming depending on what country we've negotiated with. It's at least important that on the Canada-Korea agreement, we're given the opportunity to vote on something. We have a full debate in the House of Commons on the most devastating, damaging agreement yet negotiated by any government in Canada, the Canada-China Investment Treaty, the so-called FIPA. We did not have debates, we did not have votes, we did not have a bill go to committee. And that was because it wasn't a trade deal, it was an investment deal as a standalone treaty. And it gave the people, and it gives, because it's now been ratified, the People's Republic of China the ability to bring arbitration cases against Canada for changes in our domestic legislation, whether municipally, provincially, or federally. That treaty includes no transparency whatsoever and binds us for 31 years. In the far end of the extreme of trade agreements with an investment provision, which show that the Government of Canada was dealing with a negotiator from another party that wanted to reduce the pernicious nature of investor-state agreements, we have the new text of CETA with the EU, the Comprehensive Economic Trade Agreement. Now, the Green Party won't be supporting CETA, but when I read through the investor-state provisions there, what a revelation. Quite different, night and day in terms of transparency. If the CETA agreement goes through, the arbitration cases brought by investors from the EU against Canada or from Canadian investors against the EU, the arbitrations themselves will be open to the public. The most we can expect out of any other trade agreement, such as in this case, the Canada-Korea Free Trade Agreement, is that we get public notice of the fact that these proceedings were happening at all. That's what also occurs under most of the intermediary bilateral investment treaties that were negotiated after Chapter 11 of NAFTA. Chapter 11 of NAFTA, like the Canada-China Investment Treaty, has no transparency whatsoever. The CETA agreement is at the far end of the spectrum saying, we're going to open up these arbitrations to the public, and we're going to let people with an interest actually present evidence and participate. Well, it's almost getting like a court as opposed to a private arbitration in a hotel room somewhere. Now, in the case of the Canada and Korea Free Trade Agreement, the investor-state provisions, again, fall in the mid-range. They're not as pernicious, nor do they lock us in for 31 years as the Canada-China Agreement does, but neither are they bending over backwards to try to win over people who oppose investor-state agreements. Clearly, that's the case in the European Union. They stand in opposition to CETA because of investor-state agreements, at least in Germany. But the Canada-Korea Free Trade Agreement does still include that measures adopted by a party includes municipal, provincial, federal, local governments, and including non-government bodies acting with authority from local parties. In other words, we're opening up the gates once again to investor-state arbitration suits that can cost us billions, this time from Korea. we will be, in the Green Party, both of us, voting against this treaty, and I urge other members of this House who are concerned about the impacts of this treaty to join us, no matter what their party instructions are. Thank you, Mr. Speaker.
Before we go to questions and comments, I see the Honourable Government House Leader rising.
Thank you very much, Mr. Speaker. I did want to advise the House that an agreement could not be reached under the provisions of Standing Orders 78.1 or 78.2 concerning the proceedings at report stage and third reading of Bill C-13, an act to amend the Criminal Code, the Canada Evidence Act, the Competition Act, and the Mutual Legal Assistance in Criminal Matters Act. Under the provisions of Standing Order 78.3, I give notice that a Minister of the Crown will propose at the next sitting a motion to allot a specific number of days or hours for the consideration and disposal of proceedings at those stages. Thank you.
Appreciate the notice by the Honourable Government House Leader. Questions and comments? Questions et commentaires. The Honourable Member for Kingston and the Islands.
Well, thank you, Mr. Speaker. I wanted to ask my honourable colleague from the Green Party about her party's very strong opposition to investor-state dispute resolution provisions. I talked to some experts in my own riding of Kingston and the Islands from Queen's University, lawyers who specialize in dealing with some of these disputes and writing treaties, trying to understand this issue. And they seem to uniformly emphasize that Canadian businesses need that protection in other countries, and that on the whole, Canada probably gains from these agreements. And the other thing that they would emphasize is that if you look at all of the damages that Canada has had to pay so far, if you take out the Abitibi-Bowater settlement, which reflects the value of assets that were seized, expropriated by the Newfoundland and Labrador government, if you add all that up, it comes to only about $20 million so far. And you have to put that in the context of $600 billion of foreign investment in Canada. So it's 1/30,000th. And so if you put that in the context, what I'm getting from the experts that I talked to in Kingston is that it's very small compared to the amount of investment that we're getting into Canada. And so in that context, I wanted to ask my honourable colleague if she could comment on that and to kind of explain her party's opposition.
The Honourable Member for Saanich Gulf Islands.
I thank my colleague, the Honourable Member for Kingston and the Islands. We have in common the islands. The Green Party's strong opposition is also drawn from experience, empirical data, and extensive experience with including advice from international lawyers, particularly Canada's leading arbitration lawyer in this area, and the only one who is not personally benefiting from participating in these investor-state disputes is Professor Gus Van Harten at Osgoode Hall Law School. And his view is also buttressed by an EU think tank study called Profiting from Injustice that examined the hundreds of investor-state agreement disputes around the world and finds a very distinct pattern. The smaller economic power almost invariably loses, whether it's an investor/corporation from the smaller power versus a larger government, or reversing it, a larger government investors suing a smaller country. The reality is that no U.S. company suing in the U.S. under Chapter 11 of NAFTA has ever won, and almost always the U.S. private sector company suing Canada has almost always won. So there's a...
Questions and comments. The Honourable Member for Skeena-Bulkley Valley.
Thank you, Mr. Speaker, and I thank my colleague from Saanich Gulf Islands for her comments. I suspect in the answer time that she has left, she can maybe finish that thought. But I wanted to very specifically hone in on one aspect of her speech with respect to the auto sector, and to put some context to where we are right now and look to her for some recommendations that she might support. Right now, there's a 6% trade barrier that Canada raises against Korean automakers coming into the Canadian market, and Korea reciprocally holds a 8% barrier. But right now, Korean automakers have been building in the U.S. and in Mexico, and that is the way that they have been entering into the Canadian market, avoiding that trade barrier. They're not building in Canada right now. This, I would suggest that she would also cite as a current problem in our trading relationship. What types of steps would she be encouraging a more progressive Canadian government to take to encourage some of that auto manufacturing to take place in the Canadian context as it is taking place in the U.S. and Mexican side of the border, thereby avoiding the trade barrier that we currently impose prior to this agreement being ratified. Thank you.
Member for Saanich Gulf Islands.
Thank you, Mr. Speaker, and I thank my honourable friend from Kaskina Bulkley Valley. I'm sorry. I think we need to have trade deals that have targeted measures that protect and that allow our sectors to expand, and for us to have Korean vehicles made in Canada, as my honourable colleague suggests. So tariff reduction should be tied to measurable targets in reducing bilateral trade imbalances in strategic sectors, such as in the automobile sector. It would certainly be helpful in creating a tariff-free zone if we had specific measures to require that larger Korean firms start building in Canada. We should be able to retain the ability, as the Korean government has retained its ability to intervene in its markets, to create the kind of interventions that moderate the damage of trade imbalances. And as well, as this agreement doesn't do it, but as I mentioned, even the CEO of Ford Motor Company thought we should be dealing with, the trade agreement should include provisions that would regard currency misalignment. Sorry, I'm at time. Thank you, Mr. Speaker.